It is exactly 9 minutes past 6 o'clock. Good evening and welcome to the show. You're listening to me, Gershwin Brooks, here on 919 FM. Wonderful to be in your company. And I just had this cold shiver go down my spine. And that's because sitting across from me is the legendary, the awesome host of the Rock Roadhouse himself.
Lovely to be on the legal show with you, Gershwin. This is my second appearance.
Indeed. And thank you for agreeing to do this with me.
And thanks for allowing me in the studio without my court gown.
Look, and from I understand that we're not even allowed to wear that outside of the courthouse anymore. Eh?
Apparently.
Yeah.
And
So I do, because every now and again, I'll slip out quickly, still robed, and then people look at me funny, some of the colleagues. So then I remember, oh shucks, I need to take this thing off.
all this etiquette.
Hey, we have a lot of etiquette.
I don't even know the reasons why. I just do what I'm told.
Yeah, no. These emails go out every now and again. But anyway, the reason why I got this cold shiver down my spine, Michael, is because I realized that at some point we'll have to take a musical break, say in about 20 minutes time. And you always put me under pressure. I have this internalized pressure. We have to make sure that it's a decent song, to live up to
you have impeccable taste when it comes to music.
Thank you. I'll take that. But tonight we're having a great conversation, something that I think impacts a lot of people, and that is insolvency.
That's correct.
And I think it's a very big conversation to have, and it's an important conversation to have. Because I think a lot of people find themselves under severe financial strain. I also think that all too often, I was using the example of The Office, the popular sitcom, the TV show that used to air once upon a time. And Michael, the main character, who is the branch manager, walks in, is under severe debt, he's going through a lot, he's really stressed. And someone then suggests to him and says to him, you know what, declare bankruptcy. And he jumps up in the middle of the office and is like, I declare bankruptcy. So I think the most obvious question is that how it works? Is Michael from that day forward insolvent?
No. It's a long and winding process. It's quite arduous and laborious for you to actually declare yourself insolvent. Usually, there are two types of insolvencies. If you're a juristic person, which is a company,
sure.
You would be liquidated in terms of the Companies Act, which also regulates the method and how a company would be liquidated. If you're a natural person, which would be just Joe Soap in the public, would be like a person in his personal capacity. A trust is also qualified to be a natural person, or if you are carrying on business as a sole proprietor, you would also be qualified to be a natural person per se. So in those three instances, you would not be liquidated, you would be sequestrated. So that is the difference between a liquidation and a sequestration. So in a liquidation, when it comes to a company, on liquidation, a liquidator is appointed to liquidate and wind up the company. And when it comes to sequestration and natural persons, a trustee is appointed to wind up your estate or your personal estate. So first of all, from a point of departure, to be able to understand whether you are insolvent or not, and you are at the point where you are in financial distress, you're not able to meet your creditors or satisfy your creditors, you are now getting summonses left, right, and centre, and
everyone wants their money now.
Everybody wants their money, and obviously you are now having sleepless nights because you might be able to pay some of them, but not all of them, or you might be able to pay a certain amount and spread your money amongst all the general body of creditors that you have. So maybe you are now distributing 1,000 rand amongst all the creditors, and you decide to pay out of your 10 creditors maybe 100 rand each, which is effectively a compromise. And at some stage, you're just not keeping up.
So let's take a quick step back, because the one thing that, as you're speaking, that stood out for me was when I did the law of insolvency as a student. Let's say, for example, I find myself in such a situation. I'm talking about a natural person. I'm talking about myself. I've lost my job. I don't have any income whatsoever. I'm assumingly a single person. There's no one that can assist me financially. Not my parents, not a partner, not my children, whoever. I'm alone by myself. I lived in a flat. The flat was bonded. I lost my job. I don't have any form of income coming my way. I'm getting those summonses. I then go to court and I say, please, I'm insolvent. But the issue is my bank account is zero. There is no means of me paying back. From what I can understand, in terms of the law, insolvency can't apply then, because I don't have anything whatsoever.
No, so to be able to declare yourself insolvent by way of an application to the court, which would be, in your instance, would be a sequestration as opposed to a liquidation, you have to prove certain dividend on the rand. So you have to have some kind of assets to be able to actually benefit the creditors. So if you have absolutely zero, you're not going to be able to succeed with a sequestration. So you can't, if you have absolutely zero, you're not going to even be able to get to the point of declaring yourself insolvent.
Wow.
So you do sit in a bit of a predicament or an invidious position. And you do sit into the position that whilst you have zero, you might start accumulating certain assets that they will be subject to execution by the creditors as soon as you acquire those. So being insolvent and not being able to have any assets to actually benefit the creditors on proportion to a rand. As far as I understand it, the last sequestration I did, the courts require at least 20 cents to the rand.
Wow.
So you have to prove a dividend that's payable to the creditors, and to be able, in that sequestration application, you also need to prove that the sequestration is advantageous, not to just one creditor, but to the general body of your creditors. So it's got to be advantageous to all the creditors. So the dividend on the rand of 20 cents is something that would obviously benefit all the creditors. And obviously, to be able to declare 20 cents on the rand, you'd have to have a certain minimum amount of assets to be able to liquidate.
I like where the conversation is, because what you are saying is that, look, you find yourself in such a position whereby I don't see myself being able to pay off this particular loan or this credit that I've accumulated over a particular period. I go to court. In this instance, I'm the one applying to court for insolvency. I say to the court, listen, I can at least pay these guys 20 cents to the rand and thereby get this thing done and dusted. Is that as good as it gets? Am I now a free man? Am I a happy man?
Okay, so your instance is where you apply as the person who's insolvent is what they would call a friendly sequestration or a voluntary surrender of your estate.
Yeah.
So you would essentially, as the applicant being the insolvent, would bring the application yourself. However, you would have to prove at least that there is a creditor involved, and you would need at least a letter from one of your creditors to say that you owe them the money, which is an act of insolvency. So you need to show as well that there is an act of insolvency. There are 8 of them, of acts of insolvency, which you, in this instance, say, well, you get a letter from one of your creditors that says that they've demanded payment, and you can't satisfy the payment. Therefore, you have an inability to pay your debts, which in itself is an act of insolvency. So you would have to set that out in your papers, in your application, in your affidavit, and along with that, you'd also have to set out who all your creditors are, what are the amounts that you owe them, and then you also would have to set out your assets and the value of your assets. And then obviously the shortfall or the difference, they would calculate on your assets what your dividend on the rand would be to benefit all the creditors. Now, what is also very interesting about insolvencies is technically you are insolvent when your assets or your liabilities exceed your assets.
Indeed.
Now, there's also what they call a commercial insolvency, where in actual fact your assets still exceed your liabilities. However, your liabilities you cannot convert into cash to be able to satisfy your creditors. So your assets might be fixed, or you might have hard assets that you could liquidate to be able to satisfy the creditors. However, you have an inability to do that too. For whatever reasons, maybe your assets, or you have a house and it's bonded to the bank and they're a secured creditor and they're not going to allow you to sell your house.
Yeah.
However, you still sit with this debt and you're not able to liquidate the house and pay your debts. And in that instance, you would be commercially insolvent. So in that instance, you sit in a peculiar situation where your assets actual fact do exceed your liabilities. However, you can't satisfy your creditors.
Geez, mate, I'm thinking here that I think the vast majority of South Africans, sadly enough, I think if you had to do a proper survey, if you had to do proper economic research, would find themselves in that position, that technical, straightforward, almost simplistic definition that your credit exceeds your assets. I think the vast majority of people find themselves in that situation. But I guess that there is a camel or a straw that breaks the camel's back. I guess a camel can always break the straw's back, but the point is, there's a straw that breaks the camel's back. When do we reach that point where someone now literally says that, listen, the clothing account, the school fees, the house, the car, the jewelry, the whatever that I've purchased over this particular period, it's gotten to such an extent that I have so much credit that I'm not going to be able to pay this stuff off. Is there a point that we can say that, listen, I mean, beyond the definition of your credit or your debt exceeding your assets, is there a point that you then go to court and court says, okay, now you're insolvent? Or is it really just based on the assessment that, listen, this is what your debts are, this is what your income is, or this is what your assets are, and then on that basis, clearly you're not going to make it.
Well, obviously it's also based on an accounting principle and commercial viability.
Okay.
So, you know, the question is, how deep in debt do you actually want to get? So, you know, as soon as you find that you've lost complete control and it's a runaway train, and you can just see it's just going to get worse and worse. And you're never ever going to be able to recover from your financial distress. Is it really a good time to sit and decide, you know, to actually get out of all of this? So, and all these sequestrations I've done, and we're only talking natural people now, is that a lot of people have a lot of sleepless nights when they're in this situation. And it's not really such a disaster to actually sequestrate yourself, because once you are under sequestration, you are relieved from all your creditors. You do not deal with them anymore. And all of those issues are now taken over by the trustee of your, who's entrusted to recover all the whatever debts that you might have, or any debts that might be due to you, which creditors and debtors. So you might still have some money coming in or some income coming in the future from whatever it is that you might be doing, whether it be a business, if you're a sole proprietor. So basically, you are divested as an insolvent at the time of final sequestration, divested of all your assets and liabilities, and the trustee takes control of your whole estate, and you step back and he takes care of everything. Really.
So let's talk about that then, because now obviously, as we mentioned, we talk about a friendly sequestration in this instance. I'm the one that approaches court. It's an application. I go to court and I say, listen, I can't keep up anymore. It's a runaway train. I want to be sequestrated. So I meet all the T's and C's, right? My papers are
all the requirements.
All the requirements. My papers are in order. I can prove that, listen, there is going to be some form of benefit to the creditor as well as to me, etc., etc. What happens next? Because you mentioned the trustee. In other words, let's close the process. How does it end?
When we're in the litigation process or in the application process, once you've launched your application for a sequestration on a founding affidavit and you've fulfilled or you made all the necessary essential allegations in your papers, what would happen is then the judge, because you can only do this in the High Court, because it affects status. So all matters that affect status do appear. The jurisdiction of the courts is the High Court.
Yeah.
Okay. What happens then is that if the judge is satisfied with the papers, he will then place the insolvent under a provisional sequestration. So once you place under provisional sequestration, the brakes are on. Nothing really can be done while you're under provisional sequestration. You can't transact, you can't enter into business or enter into any juristic acts at that stage. So once a provisional sequestration order is issued, okay, so here's now a very technical term, if obviously it's a legal term. So most applications for sequestration are brought on what they call an ex parte basis.
Yeah.
So an ex parte basis, and you definitely know,
Sure.
but for all of the listeners out there, is that you bring it on your own application without any service or notice to any of your creditors or any other interested parties.
Okay.
So it's brought in the absence of any other creditor or to their knowledge. So you apply to the court on an ex parte basis, and then you are granted a provisional order. On that provisional order, the court will now grant a return date, where you are now to return to court in, say, 2 to 3 months' time to get what they call a final order.
Okay.
But once you have that provisional order, you have to serve that on your creditors.
Okay.
So they then get notice that now you are under provisional sequestration.
And I guess that's when everyone freaks out.
And that's when they all freak out.
Yeah.
And then on that return day, so you'll notify your creditors of the provisional sequestration order, and then with that they will be notified of the date to come to court on that return date to give good cause or show good cause why that sequestration order should not be made final.
I get you.
Yeah. So now this notice as well is there's a lot of red tape, because what happens is you've got to publish the notice in the Government Gazette in the local paper, and you've got to also post or notify all the creditors to the estate or on your papers that there's a provisional order now.
Okay. Okay.
So yeah, it's a bit of a process. It is quite lengthy and laborious. But it's well worth it at the end of the day, because there's a lot of relief that does come with it.
I want to touch on that, and I think
yeah.
in the second half an hour, if you don't mind, I want to touch on what are the implications of sequestration, because I think it's one of those. It's subjectively speaking, as you're saying, if you are in that situation and it is a runaway effect, and you're not going to be able to settle these debts anymore, sure, it is going to be relief. But I think, another thing that you pointed to was when you get your provisional order saying that you've been provisionally sequestrated, you can't jump onto the CIPC website and go suddenly register in your company. You can't just go out there and, decide that, okay, I'm quickly going to take the little bit of assets that I have left and open up a corner shop and sell it off,
No, that would be an unlawful disposition.
Sure.
Because that would immediately fall within the sequestrated estate.
Yeah.
So it would be unlawful for you to do that. If you start alienating certain assets or whatever assets that you might have with the intention to defraud your creditors and the dividend, that would be seen to be unlawful.
Yeah.
In terms of, I think it's Section 26 of the Insolvency Act.
Sure.
So it's an alienation. An alienation is defined in terms of the Act as, it's quite broad, because an alienation could be an encumbrance, mortgaging it, selling it, hiring it out, whatever the asset might be.
Oh, okay. That's,
so and it's not just selling it, it's basically alienating it to any third party.
Sure, I get
so
you.
If you gifting do that, gifting it or donating it. So there's another aspect to this that, and I'm glad you brought it up. So in terms of the Insolvency Act, if you see that you actually is going to be going insolvent, and you decide to dispose your assets or some of your assets in anticipation of the sequestration.
Sure.
Okay, that can also be seen to be an unlawful disposition.
Ah, okay.
And they give you a period of 6 months. So it's 6 months on contemplation of your sequestration. So if you start disposing your assets within 6 months of your contemplated sequestration, that could also be seen to be unlawful and illegal.
Which I guess is a very good thing, because I mean, I could literally get rid of everything today, and then tomorrow run off to court and say, oh, by the way, I want to be sequestrated.
Yeah, and I don't have any assets.
Yeah.
Or I've only got limited amount of assets. So, however, there is a qualification to that, is that if you do dispose of those assets in the ordinary course of business, then it wouldn't be seen to be an unlawful disposition.
But I guess if you sell off the printer while you're running an office, that seems a bit dodgy.
Yeah.
Right? 084-221-2919. That's where you're going to send us a WhatsApp if you have questions, if you have any comments to make, whether it be text messages or voice notes. Those would be appreciated. Mike, I want to touch on the appointment of a trustee, because I take it that part of it is, and you know, I liked what you said there about a change in status and why we hear it in the High Court, right? Because my assumption then is that it also by implication means that you have limited capacity in terms of how you can handle your money.
So after sequestration, you are divested of your estate, completely divested. From your assets and liabilities. They take control and they have certain powers, does the trustees. So now the trustees are essentially controlled by the creditors. So after the final sequestration, there is a first meeting of the creditors, which is a meeting that's convened under the authority of the Master of the High Court.
Okay.
Once that's done, then there is I think it's the second meeting, all the creditors, there's a notice to the creditors, and all the creditors will arrive at the meeting. And then they need to prove their claims and what their amounts are. And then once all the creditors have proved their amounts and their claims, then they vote. They get a right to vote on a final trustee. Because there's a provisional trustee and then there's a final trustee.
Okay.
So then they sit and they vote, and they actually select the final or the final trustee who's going to take complete control and actually wind the estate up. So and it goes according to amounts.
Okay.
So they do make a resolve. It's like on a special resolution basis where they vote. So if I'm the majority creditor and say I am owed 100,000 rand, and the rest of the concurrent creditors are owed 5 rand, 10 rand, my vote would have a greater weight.
Okay.
And I would have a greater say in my vote to who the elected trustee would be. So that's how the meeting of the creditors work. So there are a few of these meetings that carry on. When it comes to decisions and important decisions that the trustee has to make with regard to maybe selling of immovable property or large transactions, he cannot do that. The trustee cannot act alone. He has to have the consent of the majority of the creditors.
Okay.
So you become a creditor once you have proven your claim. So you've got to prove your claim, and then you become a creditor.
Brilliant.
Now the other thing is that there are costs that are involved in the...
I was about to say, because I take it that this trustee is not going to do it pro bono or out of the goodness of their heart or whatever. No. But Mike, if you would hold that thought. Welcome back. You're listening to me, Gershwin Brooks, indeed, with Michael Timvius. Thank you so much, sir. Thank you so much for having me.
Lovely to be here.
For having me, I mean, I'm having you.
It's an honor to be here.
Look, we are discussing sequestration, insolvency.
Right.
I mean, a tough one, eh?
It is a tough one. So the only thing I can actually advise on this point is that if you are going to loan money to somebody, and you know, all sorts of things happen, it's always best to, if you are going to loan someone some money, is to secure that loan with some kind of form of security. That, you know, should the person go insolvent, that you've got some kind of security that you can rely on or execute against the loan. So, and there is a provision in the sequestration process when it comes to the trustees in the hierarchy of creditors that the secured creditors are preferent. So, or one of the preferred category of creditors. So they are first in line. So if you've secured your loan, whether it be a bond by virtue of a bond or some movable asset or a pledge or a house, that you would be first in line in terms of claiming and proving your claim to that money, as opposed to those that might be below you. So there is a hierarchy. If you are a secured creditor, you would be first in line to execute or get some money out of those assets, out of the trustee and the sequestration. And then the way the pecking order goes is, then you get your concurrent creditors, who are the ones that are really the ones that get the breadcrumbs, so to speak, because they unsecured and they only entitled to the free residue of what's left after all these secured creditors have been paid. And amongst those secured creditors is the fiscus as well.
So in other words, it's ultimately it's Animal Farm. All animals are equal, but some are more equal than others. So if you have a secured loan, then you get to the front of the line. If you don't have a secured loan, you could end up being those concurrent creditors.
The concurrent creditor, and you got the breadcrumbs if you're lucky.
If you are lucky. So you and I were talking about the trustee, and we were also talking about the costs involved, and this stuff is not a free ride. You're not saying I'm sequestrated. Oh, here's my estate. You guys decide what you do with it. You divvy it up, and I'm going to live the rest of my life, and be carefree. There's costs involved. Yeah.
So there's a twist here, because essentially the insolvent person isn't really up for any of the costs of the sequestration.
Oh, okay.
It's actually the creditors.
Shucks.
Yeah. So the trustee usually, according to tariff, and it's gazetted, the tariff, that the remuneration that the trustee is entitled to is usually about 10% of whatever assets he recovers and sells or liquidates or distributes by way of auction or by way of private treaty or sale. So whatever he liquidates,
it's quite lucrative then.
It could be, depending on obviously the size of the assets in the estate. And then if there is any pending litigation that a creditor would want to bring in the sequestration against, say, another party in recovering an asset, the trustee would then also be entitled to legal costs for that litigation and charge. Now, if you get to the stage where there is this litigation and there's no more liquidity or funds in the sequestrated estate, the creditor who brings that action could be liable to pay those legal costs.
Okay.
So it's called a contribution. So they could end up contributing to the sequestration and the estate.
Wow.
Yeah. So that is something that needs really to be carefully considered.
Yeah. So, Mike, look, I mean, obviously you're living your life. You might have a job, so you've been sequestrated. You might be in a position whereby you can continue your employment. Your employment doesn't preclude sequestrated or insolvent persons from continuing to do whatever job it is, right?
No.
As the person that has just been sequestrated, am I in a position where every single time my salary hits, then someone's going to take more of my money, and there's another creditor that comes out of the woodworks, and so on and so forth?
There are certain items that are excluded out of the sequestrated estate.
Yeah.
Just off the top of my head, there are, for instance, remuneration for work done. So if you're a salaried professional, and they do, talk about professional services, and professional people like doctors or the like, they're entitled to carry on with their profession and earn an income, which falls out of the sequestrated estate. But they're entitled to continue to maintain their family, feed their families, subsistence, and carry on their lives. And whatever surplus is left over after all of that is required to be put into the sequestrated estate and paid over into the trustee's account for distribution.
Oh, is it?
Yeah, amongst all the creditors. So there's also other exclusions. One of them is also pension monies. And whatever pension monies you receive are not available to the creditors of the sequestrated estate.
Which is a relief because it
is a relief.
Yeah.
So that's also those pension monies are protected in terms of the Pension Funds Act, and can't be attached. The only time you can attach a pension fund is in a maintenance order.
Okay.
Yeah, the only time I know when they can do that is through a maintenance order.
You know, I should talk maintenance at some point.
Yeah, no, it's not my most favourite topic, but yeah.
It's a tough one,
it's not very exciting.
No, because I've realized in all the conversations that we've had, I mean, here we are busy discussing, for goodness sake, we're discussing sequestration, which is not the easiest thing either, but, you know, and we've completely, and every single week that I'm thinking, oh, we're running out of topics. Believe me, there's so much more that you can discuss. Sorry for the segue there. So the other question that I have for you, Michael, is, I mean, for someone listening to this conversation right now, they might think, you know, there are so many benefits to sequestration. I'm going through a tough financial period in my life. I'm tired of all the creditors always calling me and harassing me. You know, I'm not even, and you know this, people reach a point where they don't even want to touch their phones anymore. Every time it rings and it's not a WhatsApp call from a friend, they're not going to bother answering it. So for someone that says that, nah, I mean, you know what, Gersh and Michael were talking about sequestration, it really sounds like an easy way out. What is the consequence for you as an insolvent person? Surely it's not all roses and sunshine. It might be relief, but it's not.
So first of all, we have a limited legal capacity. I say limited legal capacity because you can't enter into what they call juristic acts without the consent of the trustee. Now, a juristic act would mean maybe purchasing a vehicle, a house, concluding contracts without the consent of your trustee.
Wow.
Yeah. So it's almost like he's your curator or he's your watchdog. Because he's going to make sure that you don't become more indebted.
I like what you're saying there because it goes back to that issue of capacity, and I've made mention of it on the show a couple of times. A lack of capacity basically means that you're not in a position to make your decisions by yourself as an adult. For very basic, simple definition. I mean, obviously, it gets a little more
when it comes to commercial transactions.
Right. Yeah. But what I'm saying is, in this particular instance, you basically have a babysitter that determines what deals and arrangements and things you can get into and out of. But there are certain things that you are just plainly precluded from. You can't go to a motor dealership and have motor vehicle finance extended to you. You can't enter into another bond while you're insolvent, and so on and so on.
You can't create more debt.
And that notion of a contract. So say you and I, you want to appoint me as counsel on a particular matter. It's a very complex matter, and you want to sign a contract of some sorts. And let's assume either one of us is, I've been, sequestrated in this instance, and through some miracle, I can still continue to practice as an advocate. The fact of the matter is, I can't just sign the contract and say, Michael Timvius, these are the services. My trustee needs to give me permission.
He needs to give you consent.
Gee whiz, eh?
Yeah. So you can't get a bank loan or anything like that. It's difficult to do that. So what a lot of people do is that they appoint a nominee secretly to basically enter into these transactions for them or on their behalf.
Now you've opened the back door.
Yeah.
But let's assume that. But I mean, at the end of the day, and this is my question to you, is that is it a life sentence then?
No, it's not.
Okay.
So it's not a life sentence. There is an opportunity to rehabilitate your estate. Usually the period of time is 5 years, where if you let 5 years lapse, you become what they call automatically rehabilitated.
Oh, okay.
Yeah, so you automatically become rehabilitated. However, if you want to preempt the process and you want to enter into the commercial traffic and become, in inverted commas, a normal person again, an unsequestrated person, then you can bring an application to court to rehabilitate yourself. However, there are requirements to be able to succeed with that prior to the 5-year period, is that you need to prove that all the creditors have been satisfied and paid according to what they deem to be satisfied. They deem to be satisfied. Maybe they would accept the 20 cents on the rand as opposed to the 30 cents on the rand or whatever it might be, and they would deem themselves to be settled and satisfied. Or you would come up with funds to pay those creditors off. from any other kind of source. Whether it
You've
made
won the
some
lotto,
money-
you
you
got
won the
an
lotto,
inheritance.
yeah.
Okay.
So once you can prove that, there should be no issue in rehabilitating you, and you'd be returned out of insolvency, and your status would change.
Mike, I didn't ask you this. So let's say now I'm going through this sequestration. So it's a friendly sequestration, or alternatively, one of my major creditors came and said, no, based on this guy's behavior, we think we're going to run into problems. So let's rather get what we can before the ship, before this thing sinks completely. And here I go, and so one of my creditors is very happy to take me and try to sequestrate me, but the other 9 creditors aren't happy with the situation. What happens then when those 9 are like, nah, we're not going to have this guy sequestrated. He needs to pay off the debt according to what has been agreed. He took 100,000 rands from us. We want 100,000 rand plus interest.
So then return back to the general principle of a sequestration must be in the interest of the general body of creditors. So it mustn't be to the prejudice of all the other creditors.
Okay.
If it would be in the interest of only one creditor, then the other 9 are prejudiced thereby, then it's not in the interest of the general body of creditors. And that is one of the requirements you need to prove in your application before the court.
Okay.
That it's in the general interests of the general body, of the body of the creditors. And there's actually case law for that. Off the top of my head, Ahmad versus Khan, which is the trademark decision in that.
I should write that down somewhere. Ahmad versus Khan. Yeah. Okay, I remember it because I had a Mr. Khan, it was a teacher of mine, and then also Mr. Ahmad. So I'll remember that. I'll remember Ahmad versus Khan. So I'm imagining the two of them duxing it out. So yeah, that for me that's an interesting one. So just to take a step back, and I hope I'm not now regressing the conversation, but you mentioned that there's obviously the first and the second meeting of the creditors. So at that stage, let's say the creditors then say that, because remember we also spoke about those creditors that fall within the fiscus, right? The guys that don't have the secured loans. If at that stage they're saying that, listen here, brother man, I'm not happy with the breadcrumbs that are going to come my way. And as a result, it's not in the general interest of this body that you, as the bank that gave him the bond, you're going to benefit from this thing. You, with the vehicle, motor vehicle finance, you're going to benefit. But us that extended personal loans, unsecured loans, we're not going to get a cent of this, so therefore we're not happy with the situation. But the problem is those guys have the vote. They have the majority.
They have the majority vote. So you would then probably elect to try to change the trustee, I suppose. But then you'd need the vote of all the creditors at a creditors meeting to vote the trustee out.
Okay.
On certain grounds. So there's also another mechanism that we haven't canvassed in this conversation with regard to an interrogation, where maybe one of the creditors believes that the sequestrated person has hidden assets or disposed of assets unlawfully in other institutions or in other companies or the like. If there is a suspicion of that, then any other creditor who believes that their interests would want to be protected in this regard is they can subpoena the person to court, the sequestrated person to court, and an inquiry can be held. I think it's in terms of Section 55 interrogation of the Insolvency Act, which is either held, it's an inquiry held either at the Master's office or before a magistrate.
That's hectic.
And usually what happens is that the applicant would then subpoena all the documents, what they call ducus tecum, which is to produce the actual documents before the court. And that would be all his financials, whatever documents that they would deem to be informative, to be able to interrogate the sequestrated person under interrogation, under oath, under cross-examination, in front of a magistrate, to explain where did all this money go.
Shucks. So what you are saying, Michael, your namesake, my son, my eldest Michael, can't suddenly have a Porsche at the age of 11 going to 12.
No.
And then I said, no, but this is reasonable.
No.
I mean, I gifted my son a Porsche a year before I sequestrated myself.
Yeah.
Tough one. Very quickly, in the 5.5 minutes that we have left before your show officially starts, obviously we have a lot of mechanisms at the moment to try to provide some form of creditors or debtors relief, right? Where people are finding themselves as a result of the economy and conditions under severe strain. So there's debt review, there's do those qualify? Is that insolvency?
It's not insolvency per se. The debt review is usually brought in terms of the provisions of the National Credit Act. And those kind of principles apply. Debt review is very similar in that you look at your means and what your liabilities are. To be able to succeed with a debt review order is that you need to be employed and you need to be earning income to be able to succeed with that. And then obviously there is a free residue. So you would apply, you'd set out your financial situation, what your assets are, what your liabilities are, and what your income is. And then obviously they would weigh the one up against the other. And then whatever the net is after your salary and all your liabilities, if there is a surplus, then there would be like a compromise with all your creditors, and they would be paid, say, 300 Rand a month or 50 Rand a month, depending on who the creditors are. As far as I understand, once you bring the application, you do need to inform the creditors, but you don't require their consent. They do have the opportunity to object, but it doesn't serve any purpose to allow the person to go into sequestration, because they would probably be in the concurrence and just get nothing.
Yeah,
and breadcrumbs.
And I take it it's also different in that it's not a trustee that takes over your estate.
No. You get a debt review administrator who administrates. It's like going under curatorship. And he will administer your estate and your payments every month for you. And he gets a fee. I think it's 10% or whatever it might be.
So, but they're paying off your debts. They're not taking control of your house. They're not going to decide that this house needs to be sold. The car needs to be sold. They're going to take your money.
People hold on to your assets per se.
And they distribute what is left.
And the thing is that stays all execution or summonses or action. So that is also a relief. The requirement is you've got to be employed or have some kind of income.
I get you.
To be able to do that, because there's got to be some income to pay off the creditors.
And of course,
or
you're
a residue.
And you're also limited in terms of what transactions you can enter. You can't just go in again.
You can't, you can't recreate new debt.
You
can't get another loan or anything like that.
Until that is
paid off
settled.
And they're satisfied and settled.
Okay, brilliant. So and then you mentioned administration. So I know that you'll be throwing in a lot of terms, but this is to sort of delineate.
Administration is an old term used in terms of the old Magistrates provision, Magistrates Act provision, which was going under administration in terms of Section 74 administration. That's become quite archaic, and no one really applies it anymore. And it's kind of, you could say, been substituted by this new provision of debt review, which is brought within the ambit of the National Credit Act.
Brilliant.
Which allows that.
No, thanks for the clarity.
So,
Mike, these things happen when you're having fun, eh? We're out of time. We're literally out of time. There's 2 minutes left before we get to 7 o'clock. Very quickly, I just want to read Shane's WhatsApp. He says, "Good evening, gentlemen. Great to hear both of you discussing these kinds of things. Probably even more important in the complicated environment a lot of people find themselves in. I appreciate your work. Have a great evening and take care." And it's our usual suspect, Mr. Shane. Thank you so much, man.
Thank you, Shane.
We love it. We love it. We love it. Listen, Michael, thank you so much. It was really awesome having you.
It was really an honor to be on your show. Thank you, Gershwin.
Dude, I don't know why you even say that, because it's an honor having you with me. But anyway, cheers, folks. All the best until, so that we don't bore you any further with us complimenting each other and giving each other platitudes. Cheers till next week.